Your Honors, Brian Moseley for the plaintiff, Ms. Ruth Mitchell. I'd like to reserve 5 minutes for rebuttal.
All right, sir. You may proceed.
Your Honors, this is a claim, obviously, under the Governmental Tort Liability Act related to an injury to my client that she had back on June the 3rd, 2018, as she was leaving the church that she was attending. She tripped on an unlevel and dangerous portion of the city sidewalk. We went to trial on this matter last summer. The court ruled in favor of the city by essentially finding that there was no constructive notice of that condition by the city. That is the primary issue that we have on appeal, is that the evidence that was presented actually preponderates against that finding by the trial court. I think it's important as well, though, to note that the trial court made several legal decisions that were erroneous as well, mainly in ignoring the precedent set down by the Supreme Court in Hawks v. City of Westmoreland, which essentially identified that constructive notice, as it pertains to the Governmental Tort Liability Act, is not removed by Section 205, the sections that deal with the failure to inspect by a municipality in discretionary function the municipality. We presented that both at the summary judgment level. We presented it again at the trial and at the closing of the case, and at each time the judge essentially ignored that precedent set down by our Supreme Court. I think it's helpful if we look at the sort of historical basis of the GTLA as well as the liability for municipality for sidewalks. Prior to the enactment of the GTLA, municipalities, of course, still had sovereign immunity, but there were certain exceptions to that, and as it pertains to unsafe conditions of sidewalks, there were two in particular that removed immunity, the sovereign immunity, either under a public nuisance doctrine or under the city's proprietary functions. So as the city, as the owner of a sidewalk, they had a duty to maintain their property, their sidewalk, and that duty also included an obligation to inspect the sidewalk. And that's important for this issue because, as we know, constructive notice is a condition that had existed there long enough that someone using reasonable care could have discovered that condition if they had the duty to actually look for it. And as the case law is clear, a city has a duty to maintain their sidewalks, and part of the duty in maintaining the sidewalks is specifically to do an inspection. Now, in 1973, when the Governmental Tort Liability Act was enacted, immunity was expanded for all types of functions, not just the proprietary or governmental functions, but also the proprietary functions. However, specific sections were included that remove that immunity for unsafe conditions of streets, sidewalks, that's Section 203, other types of structures, that's Section 204, and then general negligence under 205. In this situation, an unsafe sidewalk, you'd have removal under Section 203. 203 says that if there's an unsafe condition that the city actually knew about or had constructive notice about, then the immunity that's conveyed under 201 is removed. And that's the situation we have here. Now, in the trial court's decision, he relied upon the McMahon versus City of Cleveland case. And that was a situation where the plaintiff had alleged that they had tripped over an unlevel sidewalk that was caused by a tree root. In that case, the court found that there was actually no evidence presented by the plaintiff that the tree root had actually caused this unlevel condition of the sidewalk. And the court said that that was this great fallacy. And I think because we had a tree involved in this case, the trial court kind of wanted to mirror its ruling on that McMahon case. Unfortunately, in our case, we had, I think, 6 witnesses, each of whom said that there was the cause of this unlevel sidewalk was tree roots. As a matter of fact, 2 of the witnesses were city witnesses. The city alderman, who is for the ward where this location took place, testified that it was the tree root that caused the sidewalk to become unlevel. And the city's own street inspector testified that it was the tree root that caused the sidewalk to become unlevel. In fact, there was no evidence that said that there was any other cause other than the tree root that caused the sidewalk to be unlevel. And the reason that is, I guess, somewhat important is because the other evidence in the case shows the timeline of how long this condition had existed. We heard from Barry Johnson, who is the facility manager for the church where this incident happened, in front of the church where this happened. And he started working for the church in 2012. And he said that the sidewalk was in that unsafe condition since that time. Again, this fall happened in 2018, so roughly 6 years prior to this incident, the sidewalk was unlevel. He also testified that they were having problems with this tree. The tree had died, and in 2015 or 2016, they actually removed the tree. So from that point forward, there was no change in the sidewalk. The condition essentially was a static condition from that time. So roughly 3 years prior to this fall, the condition was static. I'm sorry?
How do we know there was no change in the sidewalk?
Because the testimony from Mr. Johnson was, so after they removed the tree, was there any change? And he said very little. He said very little change. So his personal observations were that the sidewalk was essentially in a static state from that time forward. Plus, I mean, just common knowledge, we know that a tree root, in order to change the elevation of the sidewalk, is going to have to continue to grow. When you kill a tree, cut it down, that tree root's not going to continue to grow and push that sidewalk up.
Who removed that tree?
Well, this is interesting because this is another error of the trial court. The trial court said that the city removed the tree. I wish that were true, because the city standing there in 2015 right next to the condition that caused my client to fall, I could say, well, hey, you were there and you would have seen it. But honesty with the court, the church ultimately had to remove the tree. So the church had to pay somebody to come out and remove the tree. Now, they did report the tree to the city, and so the city was aware of the tree. There was a dispute as to whether or not the city was actually aware of the condition of the sidewalk. But again, this appeal involves constructive notice, not actual notice. We understand this court has to give credibility weight to the trial court, and the trial court found the credibility as between the dispute between Mr. Johnson saying, I told the city about it, and the city saying, no, we weren't told about it. That's up to the trial court to decide, unless there's something But
the city didn't keep records of
the city did
complaints.
not keep records. As a matter of fact, this incident itself that we're here about, the only record is from the insurance company, Travelers Insurance Company, when they took a report. But the report of the claim, the work that was done to fix, to grind down the elevation change, none of that was recorded. No records were kept, no photographs were taken. That goes to one of the last issues that we have, and that is this exemplar photograph that we had just a few yards away from this, down the sidewalk, same stretch of sidewalk. We found a condition that would have been very similar, if not exactly alike, the condition that caused my client to fall. We wanted to submit that because it was the best evidence, because the only other way to prove that had been destroyed by the city itself. The court refused to allow that to come into evidence, but we did submit it as an offer of proof regardless.
And what was the court's reasoning for refusing to allow that to come into evidence?
Relevance, that it simply wasn't relevant because it wasn't the exact spot where she fell. And I wasn't submitting it to prove that. I was just submitting it to prove that this was a similar condition. I have very few seconds in this.
Let me ask you,
Go
let me
ahead.
make sure I understand a part of your argument. You're not relying on actual notice in any way.
No.
We're only looking at constructive notice.
Correct.
Okay.
Correct.
I
Absolutely.
wanted to make sure of that distinction.
Would that I could debate that issue, but I don't think, I honestly don't think under the standards that this court can reverse the credibility determination based on the actual notice. But that doesn't mean that there can't be both types of notice involved in a case. So you can have constructive notice without actual notice, and that's what we have here. The evidence was uncontroverted that this condition was there. Nobody from the city came in and said, well, we had inspected that area a month before, 6 months before, 6 years before, and it wasn't like that. It was a nice level sidewalk. So the only evidence that was there was that the sidewalk was in that condition for that period of time. And I'll sit down and come back on rebuttal.
Thank you.
Good morning, Your Honors.
Morning.
My name is Dwayne Willis. I'm here on behalf of the Appellee, City of Franklin. A lot of my points are going to touch on exactly what the questions were for the previous counsel, for the appellant. But what this does boil down to, as he said, is that this is now an issue of constructive notice. It was not solely an issue of constructive notice when we tried this case. When we tried this case, their main goal, the plaintiff's main goal, was actual notice. She believed that they had a witness that told the city at some point that there were problems with the sidewalk. As that proof developed, as was the case with the majority of the witnesses in this case, it was very speculative. It was very specious. He was not sure which section there was involved. He did not know specifically where she had fallen. He had been told by a third party that it was in front of the church, but hadn't gone out and looked at that specific section himself. He was just like, oh yeah, there's problems out there. When he was asked specifically by the trial judge, who wanted additional explanation about what was going on, he explained, I reported the entire block, not just that section of sidewalk. So we don't know what condition that section of sidewalk was in at the time. When he said there was an issue with that sidewalk back in 2012, he said it was between 1 inch and 2 inches, probably more than 2 inches. It was never at that height. And he, as testimony came, it was then changed to, well, it may have varied a little. The tree root argument is relatively new. I believe that's just in response to the fact that the judge cited to McMahon. I don't believe the judge cited to McMahon because it was tree root similarities. I believe the judge cited to McMahon because it was a case where you had factual proof, you had no constructive notice, and a judgment was awarded for the city. So I think that was the citation. But assuming that under the umbrella of constructive notice, which was raised at trial, you can now on appeal raise an issue of a subsection under that of tree root, that still doesn't raise to that level. The witnesses that talked about the tree root, Barry Johnson said he can't remember when he removed it. He just knew he removed it quite a time afterwards. Sergeant Hellstrom said he doesn't recall if the tree was there or not at the time of the accident. Daniel McGinley testified he thought the trees in the area makes them, meaning the sidewalks in general, unlevel a little bit. The alderman testified that she assumed the tree root grew under the sidewalk. There's no actual proof that the tree root was the cause of this, that the tree that was cut down was the only tree in the area. The sidewalk was still there. It could have been dug up. There was none of that. The judge pointed out that there was a drainage ditch right next to that could have also been an issue. And as you can see from my argument, and this will be continuous for the next 12 minutes, it's fact after fact after fact. These are all factual arguments for constructive notice. Factual arguments the trial court spent 13 pages in his order reviewing and saying, this is what I found. It's also interesting that while actual notice was argued at the trial court, it's not being argued on appeal. The appellant specifically said in her brief, I'm not bringing up the issue of actual notice because the trial judge saw the witnesses. He saw Mr. Johnson, who said he told somebody from the city, and he saw the person from the city saying, he never told me that. The only time we talked about anything was after the fall. He found the witness for the city to be credible, Mr. Johnson's testimony to be again speculative, and found more credibility in that witness. That should be given considerable deference and not deferred, and that's why they didn't appeal the issue of actual notice. Surprisingly, they also didn't appeal the partial summary judgment that was granted to the city. The city got partial summary judgment, as he noted, under Section 205. 205 is the section which gives them discretionary immunity based on the fact of failure to inspect or a substandard inspection of the sidewalks. The appellant continued to try and bring up the inspection throughout that time and state that because of Hawks, all of that should have been brought in. I disagree with that assessment. I think What was excluded was how they conducted their inspections or whether they conducted inspections. That should have been excluded. Having the expert testify as to state standards of other places that don't apply specifically to my client didn't have any bearing on the case, and the judge recognized that and continued to kick out stuff about inspections. But what was factually in front of the court was that nobody from the city had looked at it before. We have to look at Hawks in the box in which it was performed. In the Hawks case, the fire hydrant valve was underneath the ground, and the only one that had access to it was the city. So what Hawks was saying in that situation was saying, if we don't allow inspection to come in as far as constructive notice, then we can't specifically find a way to have constructive notice. You are then requiring actual notice of this issue because nobody else can see this. It can't be found by anybody else when it's underground and solely in their control. We're talking about a sidewalk that is in front of a very populated church in downtown Franklin, which has festivals that the 13 witnesses that testified said bring tens of thousands of people per year to this area. And the findings that aren't speculative was that there were no reports of this issue before. There were no falls in this area before. The appellant herself brought numerous witnesses to support her side of the case, and all of those witnesses said the same thing. We don't know of anybody that's fallen or had a problem with that section of the sidewalk before. So it's surprising that that was not brought up.
So failure to inspect is not anything we're concerned with at this, in this review. Is that correct?
That would be my position, that yes. But
Okay.
if we were going to deal with failure to inspect at this point, that should have been brought up by appealing the motion for summary judgment. That was not, and thus that issue is pre-terminated.
I understand that part of the argument. I'm just trying to make sure what we've got in front of us at this point in time.
Yeah, and I think what we have in front of us then is constructive notice, which to me is 100% a factual argument, which the judge heard two days of proof over. There are three types of constructive notice. Obviously, there was no argument that they created or caused the condition, so that one was out. The third one was raised briefly in the appellant's brief. Again, I think that was in response to a citation by the judge. It wasn't argued, it wasn't argued at trial, so I don't believe that one would carry the day. It is pattern of conduct or recurring incidents or general continuing condition. That doesn't exist in this case. As the appellant pointed out in his brief, her brief, this is a static condition. It's not something that changes over time. What you're looking at in those situations is what you'd be looking at in Blair versus Westtown Mall, where they had buses that came into the spot where the plaintiff fell continuously. Those buses, as they do, would leak oil. The defendant would clean it up, the buses would come back, the oil would recur. That's a recurring condition. That's when you get constructive notice, because you should have known about a situation recurring when you have facts around it that make it recur. That's not the situation in this case. If that condition did exist for any length of time in the condition alleged, then it would be a static condition and not that one. So what you find is then you're just stuck with the length of time argument. And the length of time argument specifically says in the case law that it's not just length of time alone that's determinative as constructive notice. It's the nature of the business, its size, the number of patrons, the nature of the danger, the location, along with the foreseeable consequences. Nature of the defect has a bearing on it. All of that, again, creates a very factual argument, which the judge heard all these witnesses on. And what he got was a lot of probablys, a lot of maybes, a lot of could-haves, a lot of I think so's, but not a lot of actual proof. No one could say what that section of sidewalk was at the time of the fall. No one could say what exact height it was before. No one could say if it was that specific section that had an issue before. Everybody could say that nobody had fallen there and nobody had reported a condition there before. So the facts, again, don't support that situation. It doesn't make that, it doesn't have the firm evidence that would be required to make a constructive notice argument from that side. I think the last thing I would point out is, again, what we're looking at in this case is extremely factual. Constructive notice deals with all of these facts on a regular basis. You have to look at what did the judge have in front of him. And one other thing I would point out would be the expert in this case. The judge had the expert in front of him. This expert took one measurement, period. And that measurement was to have opposing counsel stand on the back of a yardstick in the area of the question, stuck the plaintiff's shoe underneath the front of the yardstick, took a picture of that with the measurement on there with the ruler resting on the shoe. Now, arguments were made that it wasn't actually touching the shoe. The pictures are in the trial record. You can see that for yourself, Your Honors. It is, in fact, touching the shoe. It would have been very simple for him to take one more picture without the shoe in there and tell us if that was the height, or do any more testing. The proof is replete of what I cross-examined him with, showing that that was not done. The judge found that not to be very credible and didn't put any credence in the witness himself as an expert. So we don't have any witness saying that this is a specific size. We don't have any witness saying this was caused by a tree root. We don't have any actual witnesses specifically saying, I know for a fact this is caused by a tree root. We have a lot of different fact witnesses coming in and saying at different times, this is what I saw, I think, I'm not sure. The judge had all of that. The judge very eloquently in his 13-page order recited all this. We believe that those fact decisions should be left at the behest of the trial judge, and would ask that this not be overturned and that the appeal be dismissed. Leave the rest of my time for questions if you have any.
Thank you.
Thank you very much, Your Honors.
I can go ahead and I mean, Your Honors are going to have it, but I can literally read from Hawks. It says, proof that a governmental entity failed to adequately inspect property or improvements which it owned and controlled is directly relevant to the question of whether it had constructive notice of the dangerous or defective condition resulting in injury.
Is failure to, as Judge Stafford asked, is failure to inspect an issue here?
Absolutely. In both Hawks, which dealt with 204, it said, and in Kirby versus Macon County, the court has been very clear, the Supreme Court's been very clear. Section 205, the part that deals with the failure to inspect, is separate from sections 203 and 204 under the GTLA. You can have removal under section 203 and not have removal under section 205. The summary judgment that was granted and which counsel has alluded to was under 205. What Hawks specifically said is the city still has to inspect its own property. If the city no longer has that duty, and of course there's no statute that has relieved a municipality of that duty, there's been no case law that's relieved a municipality of that duty, then how can you ever have constructive notice? Constructive notice has to be based on a duty to inspect and a failure then to inspect. And it's important because in both the McMahon case, we talked about the tree root and the difference between what was factually found in that case, that there was no evidence that the tree root had caused this, and in this case, where there was witness after witness that actually said the tree root has caused this condition. The second thing that the trial court ignored was that in McMahon, the city actually performed inspections. So the city in the city of Cleveland had actually done its duty. It had actually gone out and looked. As a matter of fact, not only did it do periodic inspections, but it did extra inspections before every event. If there had some special event downtown, the city of Cleveland would send its inspectors out to make sure, hey, are our sidewalks still safe? In this case, the evidence was very clear, and it was uncontroverted, that the city of Franklin did no inspections of its sidewalk, especially for this sidewalk because it was adjacent to a state route. It was responsible for sidewalks, the state was responsible for the street, and so it never did any inspections of that sidewalk. If it had done an inspection, it would have discovered this. It has a duty to do that inspection, therefore, again, the evidence preponderates against the trial court's finding that there was no constructive notice. There was a case that I found too that's not exactly the same, but it has the similar issues, and that's the Biggs versus City of Nolensville case that I think this panel actually decided back in January. And that came to the same conclusion, and that is there was a condition that, as a matter of fact, my expert was in that case as well, and there was the same issue with that case, Mr. David Johnson.
Wasn't that a summary judgment issue?
That was a summary judgment, absolutely, compared to that. But in that case, it was the same issue of this condition had been there for 6 years, and a 6-year period of the condition, when we're talking about the Blair, it's a continuing condition. It's not a repetitive condition or repeated incident. That's one way to show it, but it's a continuing issue. When this condition is static and has been there for 6 years or 3 years or 2 years, then that's a static condition that's continuing, and that establishes constructive notice under Blair. The court excluded my expert opinion regarding the inspection procedures, again, erroneously saying that Section 205 maintained immunity, blanket immunity to a city, despite the fact that the clear holding of Hawks says otherwise, that it is specifically relevant to the issue of constructive notice. 203 says you either prove actual or constructive notice, and you prove constructive notice by showing a failure to inspect and a duty to inspect and maintain. I don't know how clearer you can make it.
You're not saying that a failure to inspect automatically establishes constructive notice, are you?
No, that's a component of constructive notice. You have to have
It's
a
just a
condition.
factor.
Yeah, you have to have a condition that exists to be found, which in this case we've established, and then you have to have a condition that can
But if
be.
you've got the condition that's there, and you've got a failure to inspect, you're not asserting that that automatically equates to constructive notice, are you?
There's essentially what I would say 3 steps. You have to have the condition. The condition has to be one that can be found using reasonable diligence. And then you have to have a duty on the part of whoever you're ascribing constructive notice to actually look for it. So in this case, we have the condition that was there. It's been there, since 2012, at least since 2015 or 16 in that exact same condition. We have a city's own standards that says any elevation change in excess of 1/4 of an inch is an unsafe condition and must be remedied. So the city's own standards say that this was an unsafe condition. Had they looked for it, it was there to be found by somebody who's doing these types of inspections. And then that final element, did they have a duty? Yes, they did. They own the sidewalk. The city owns the sidewalk. They're responsible for maintenance. So,
Well, how can
yeah.
that be if it's a discretionary function?
Because again, the discretionary function immunity only applies under 205. 205, it's not discretionary to maintain your property. The courts have said, and that predates the GTLA, the reason that a municipality did not have immunity for failing to maintain its own property is because it owns that property. It is treated like an owner, just like Walmart or any other business, any other person has a duty to maintain their property. A city does too. Under 205, a discretionary function would be, do they want to build a sidewalk? It's discretionary whether to build that sidewalk. If they don't build the sidewalk and somebody's walking along a shoulder of a street and steps on a rock or steps in a hole or something like that and twists their ankle, then, that was, and says you should have had a sidewalk there. Well, that was discretionary. They didn't have to have the sidewalk. But once the sidewalk is built, it's not discretionary anymore. They have a duty to maintain their property. They can't escape that duty.
Thank you.
Mr. Moseley, one
Yes.
more question, and you've talked around this issue a little bit, but as far as the Section 205 summary judgment, you're not purporting to raise any issue with this court regarding that particular order, are you?
No. I put that in the complaint initially. I addressed it. Hawks doesn't necessarily, address 205 specifically. I think it was an interesting argument to raise and a thought exercise. But where does it get you in the end of the day? Under 203, you have removal of immunity. Under 205, you have removal of immunity. You can't get double removal of immunity. It's either removed or it's not.
Thank you.
So, yeah, thank you.
All right, folks, thank you for your argument. We will take this matter under advisement and attempt to render an opinion at the earliest time possible. We'll be in recess to the call of the docket this afternoon.
All rise.